Supreme Court doesn't have an army. It can't march on the government. So now, how many debates are you to have, and between whom? And Parliament has also accepted the basic structure doctrine.
Are you suggesting that when governments are powerful, and it can be any party, when governments are powerful,
yes,
the collegium or the topmost judges of India are scared?
Yeah.
Are they scared?
Yes, possibly.
The one case that you have always been criticized for is Union Carbide, the Bhopal gas.
That's right.
And you say
there's a chapter on that.
There is a chapter on that in your memoirs. Do you regret to date having taken that case?
Yes. In retrospect, yes. Just as one regrets a lot of things in one's life.
Is that your biggest regret?
Yes, perhaps it is. Court has to now consider not only the federal structure, it also has to consider why, without the consent of the state legislature,
the
assembly, it has been reduced from a state to
a union
territory. In fact, not only am I worried, at the beginning of the term of the present government, which is right in 2014, I had mentioned this, that we are merging into a Hindu state. Not a secular state, but we are now diverting into a Hindu Rashtra, Hindu state.
Mr. Nariman, while going through your memoirs, I was struck by a chapter that spoke of a case that you had won, but that you wish today that you had lost. And that's what the chapter is in fact called. I have the book here in front of me, Before Memory Fades, your memoirs.
That's right.
And you were speaking of what we have come to know as the second judge's case, the case that actually gave birth and legitimacy to the collegium system.
That's right.
The collegium has been in much focus the last few months. It's been a point of debate between the government and the judiciary. You have become a skeptic, a critic of the collegium that you championed in court as a lawyer. Why do you think that the collegium is not working? Why do you wish, as you say in your memoirs, that you wish you had lost that case?
In the first place, judges, and when I speak of judges, I mean judges of the Supreme Court, ably decide cases as they are meant to. And my own view is that judges are not competent to ascertain and decide who should or should not be a judge of the superior courts, or who should or should not be transferred from one high court to another high court. In fact, that somehow detracts from the business of judging, because the judiciary is an independent organ of the state and the sole and exclusive interpreter of the Constitution. There's no one else. And that's how our Constitution is framed.
Yes. Everything
depends upon how the Supreme Court ultimately decides a particular case. Take the present dispute about Kashmir, for instance.
Yes.
Whatever the Supreme Court ultimately says will be the final word on the Constitution with respect to the changes that have been effected. Like that. So I think it detracts from the business of judging cases. As it is, we have an overload of cases. And how to decide them, how to speed them up are matters which are of prime concern.
When you were arguing otherwise,
yes,
in the second judge's case, did you believe differently, or were you just doing your job as a good lawyer?
The job as a good lawyer, that's right. That's what one does, because one gets one. But the important thing to remember is that this came out of the hat, as it were, when you argued the case. Because this was Justice Verma's bugbear. He said that we must have the final word with the judiciary, which I agree. The final word must be with the judiciary.
Yeah.
And in fact, I have mentioned this before, that Chief Justice Venkatachala, a very respectable former Chief Justice, had propounded after this judgment came out that as to how a commission, a national commission should be formed. And he had said it should consist of 5 members, 3 senior judges of the Supreme Court, 1 an outsider, the law minister, which is necessary, and a last person, one last person, an expert who has an independent view of things, which would be a rough and ready way of choosing who should be a judge, who should not be a judge, who should be transferred, who should not be transferred. And actually, the BJP government itself introduced a bill along these lines. That it was in 2003. But the bill lapsed only because the elections were called. That's all. So the new twist that was given to the commission, which was wrong, where again I appeared, and it was struck down ultimately.
Yes.
But it was totally wrong,
But
because
you know
that
what?
said that apart from judges, if there is amongst independent members, someone could veto what the judges had decided, which is not correct.
But today, what you're saying,
Yeah.
that the collegium keeps the judges more immersed in transfer and appointment of judges than actually hearing cases.
Yes.
This is something that the government's former law minister Kiran Rijiju kept saying.
Yeah.
And it became quite a public dispute. It seems to have settled down right now.
Yes, it seems to have, but I believe that is so, because it requires in the first place a regular office of the collegium, which the collegium doesn't have.
Right.
A regular office, a whole tabulated statement of how many judgments Mr. X or Mrs. Y have delivered, what has been their fate, etc., etc. It is a very, very complicated process. It's not an easy process.
So, do you agree with the government's position or the government's diatribe against the collegium?
I'm not on the government's position. I don't know what the government's position keeps changing. My own view is that a commission, as recommended by Chief Justice Venkatachala when he was appointed chairman of the National Review of the Constitution, is the ideal situation. That should be. Because take for instance, and this is what I wrote about 2 weeks ago, the
Justice Muralidhar case.
Muralidhar's non-appointment, if I may call it that. Now, here's a man of extraordinary ability, great competence, totally honest and so on, not a word whisper against him. And yet, what happened was very tragic.
You say that the Justice Muralidhar's non-appointment, you call it tragic. Can you elaborate? Because the focus has been entirely on the non-appointment to the Supreme Court. But the argument that you made in your op-ed in the Indian Express, that that well before the collegium had to decide whether he came to the Supreme Court or not, you don't believe the collegium acted as it should have.
See, what happened was, when he was already Chief Justice of the High Court of Orissa, Muralidhar, at that point of time, and had only about 6 months odd for his retirement as a judge of a high court, the collegium decided, since he was an efficient and honorable and decent judge and had contributed much to the Orissa High Court, that he should be transferred to one of the principal high courts in the country, namely the Madras High Court. They recommended his transfer, which is a duty which they undertake under Article 222 of the Constitution. They recommended. The government sat on it, did nothing. It didn't say yes, it didn't say no.
Yeah.
But the fact that they sat on it meant it was not to come in. Then the question came. The Madras High Court Chief Justice was retiring, the incumbent Chief Justice, and someone had to go to the Madras High Court. So the collegium was asked who should go. And the tragic thing was that they withdrew what they had recommended and then decided that Mr. X, another gentleman, should go to the Madras High
So
Court,
they
which
did
was
not even
accepted.
send Justice Muralidhar to the Madras High
Yes.
Court as they had originally
Yes, which was
recommended.
I mean, inexplicable. Of course, one doesn't require an explanation under 222. That has been held now repeatedly. But that itself is a tragic thing, because if you don't have an office, you don't have an independent agency to deal with appointments, it becomes a big problem.
The big defenders of the collegium
Yeah.
make the point that it is an imperfect system, but
Yeah.
it is a better system.
But then perfect it.
Now, how?
You see, the simple reason is insist upon what the bench in the 9 judges case had said originally, the original that constituted the collegium.
Yeah.
Namely, that within a stated time, if the government does not approve of the appointment, it is to be treated, their non-approval is to be treated as malafide. That's the judgment. But they don't follow that, because the Supreme Court doesn't have an army. It can't march on the government. So it has to depend upon persuasion about repeated attempts to do things.
There is another case of a recommendation that the government has not responded to or not action, which is the case of Saurabh Kirpal. I don't know if you've been following that case.
Yes.
But again, the collegium has in fact twice.
Yes, recommended. And the fact that they don't appoint him is to be treated as malafide has never been pursued. No one has said that.
So what does this suggest to you? Does this suggest to you
It
that
suggests to me that there is a deficiency in the system as it works today, and therefore it should be tuned up.
is the
If you want to
collegium weak?
retain the collegium system.
Let me ask you this.
Yeah.
Do you believe the collegium is weak, or do you believe that the collegium has too much power within the judiciary? Which one is it? Because you've also spoken
Sometimes one, sometimes the other.
So it's
it
both.
Depends. Yes,
It's both.
It's both. You see, very decent people, people who are deserving, etc., as compared to those who are appointed, are not appointed. What does the public feel? I mean, this is the problem. Therefore, it's far better to have a commission. But if you don't have a commission and want to retain this, then you must devise some method by which you establish your clout, as it were.
The government, or rather the vice president, no less, has also been arguing or challenging the basic structure of the constitution, the basic structure doctrine, as it were, saying that there is no parliamentary legitimacy to this as a constitutional principle.
But that's not correct. I mean, that again, you'll find there's an article of mine which will probably appear in a day or two, because somebody wrote an article that we must have a debate on the
basic structure.
On the basic structure. Now, quite frankly, there have been several debates, several decisions of ultimately bench of 9 judges of 2007, which takes the view that the basic structure doctrine is the correct doctrine. So now, how many debates are you to have, and between whom? And Parliament has also accepted the basic structure doctrine, because it has said in an amendment of 1978, a constitutional amendment, that you cannot abrogate or suspend Article 20 and 21 ever, not even during an internal or external emergency.
Yes.
So even Parliament has accepted it.
One of the arguments you've made is that the collegium particularly falters when the governments are too powerful, when what you call majoritarian governments, by which you mean very powerful governments.
Yeah.
Elaborate on that. What do you mean by that?
See,
you said, God save us from majoritarian governments.
Yeah, you see, this is, if you just trace the history of what happened during the first 10 years of 15 years of the Supreme Court, when the word used was consultation.
Yes.
And consultation didn't mean anything but consultation. It didn't mean concurrent. It is a matter of record that of the 500 odd instances that were in which the Chief Justice was asked to give his opinion as to who should be appointed a judge of the High Court or the Supreme Court,
yes,
in almost 99% of the cases, it was accepted. It was only in a rare 1 or 2 cases which were then ignored. But the experience that came after the first judge's case, which said that no, a reading of the Article 217 of the Constitution clearly shows that it doesn't mean the concurrence of the Chief Justice, it only means the consultation is required. Then the government indulged in asking number 3, number 4 of the Supreme Court for his opinion and preferring his opinion to that of the Chief Justice. Now that was subverting the whole.
So are you suggesting that when governments are powerful, and it can be any party, when governments are powerful,
yes,
the collegium or the topmost judges of India are scared?
Yeah.
Are they scared?
Yes, possibly.
What are they scared of?
I can't.
What might they be scared of?
I don't know. You're quite right. They shouldn't be. But you can see they were known in the emergency as the bandwagon judges.
Yes.
Yes, I could name them, but one doesn't like to name people now. Half of them are dead. So what's the use? They're bandwagon judges. They turned on the bandwagon. Oh, this is a great thing. This is government is magnificent, etc. Hoping for some benefits in retirement, etc. Because they do get these benefits. You can't exclude them.
Let's talk about the emergency, since
Yes.
you've mentioned it.
Yes.
And it's a big part of your own personal journey.
Yeah, that's right.
You were ASG, law officer in the government, when Indira Gandhi declares emergency. And you quit from your post. And one of the self-deprecating things that you write in your book is that you told your wife, I wish I was Attorney General at this point, because maybe somebody would have then noticed the fact that I resigned. And you say the New York Times, because the media, of course, at that time was not standing up to power. The New York Times had a one-line mention of the fact that you had resigned in protest as ASG. You move out of your official residence and you actually go looking for a home. And if I'm not wrong, where we're sitting talking to you today, this is a home that became your home because you quit during the emergency. Can you take us back to that time and what you felt during Indira's emergency?
Yes, you see, there was another problem, which today is a very important problem. Sometime before the emergency, the Chief Justice Ray was moving into the Supreme Court building in his car when someone dropped 2 large bombs, alleged bombs, into his car, which never exploded.
Right.
It, of course, affected him deeply because he was he was confined to his bed for a few days and so on.
Yeah.
And this created a stir. The Attorney General, Niran Day, then spoke to the Chief Justice and said that that officers of the government who appear for government are in danger now. It's quite clear. And therefore, we must have something done with respect to each of the 3 law officers, the Attorney General, the Solicitor General, and the Additional Solicitor General, which was me.
Yes.
And lo and behold, we had some chap move up to our place. My wife was very disturbed because he had to set up a tent on the garden in Safdarjung Lane, a very nice, delightful lane, etc. He had to be fed and given coffee and tea and so on, whatever it was. But one important thing, you see, that this business of protecting the people that comes to my mind, and which I must tell you, is that whenever I went out for a walk after that, in the evenings to the Ashoka Gardens, this man would come with me, and I'd feel quite secure. Believe me, when I resigned, for a few days that resignation didn't permeate downwards or upwards, and nobody quite knew whether I had resigned or not resigned. And the man remained with me for a while. Then, of course, the ministry moved him out. And for a few weeks after that, I felt insecure. How can I, Additional Solicitor General, going out for a walk alone without a... You see, this strike must be striking all these ministers, etc.
Yes.
A whole host of them who are provided with all this paraphernalia, which is quite unnecessary to my mind. I mean, it's very rare that one has this problem of someone wanting to kill you. Hardly anybody wants to kill anybody as such. Therefore, this evokes a certain coterie amongst the elite, that I am deserve to be protected amongst everybody else. I am somebody important to be protected. I must have a guard around me, someone to walk in front of me, someone to walk behind me, and a car to go with me, a car to go behind me, which is quite unnecessary. Because when you see the Scandinavian countries, the king and all these chaps go on their bicycles all over.
But-
the Indonesian president does the same thing.
But
We don't.
apart from feeling initially insecure without your security,
But you have to work it out.
of course, what made you quit? Why, at a time when so many people caved? It was certainly not the judiciary's finest hour. It was the opposite. What made you?
Because I felt that I will never be able to appear for the government and make my submissions, which I used to make.
Yes.
That's the problem.
Yes.
It's a matter of conscience. That's all. That's all. Therefore, I quit, and that's something I quit from Bombay when my wife and I had gone for a week into Bombay, and
Yes.
and you see in the train, we went by train, and I read that the Home Minister, this is just 3 days before the emergency, that the Home Minister and the Home Secretary, the Home Secretary had been changed. A new Home Secretary had been brought from Rajasthan. I took no notice of it. Maybe,
Yes.
maybe not
Yes.
be. But that perhaps was an indication that something was afoot. And then came, of course, Mrs. Gandhi, the refusal of a complete stay by Justice Krishna Iyer in Mrs. Gandhi's election case
Yes.
in the Supreme Court.
In your book, there's a very interesting story. You've quit as ASG, and you are out for a walk with the then Australian High Commissioner, who's your friend, and
Mr. Grant.
Mr. Grant, and he has met with Mrs. Gandhi, with Indira Gandhi, and she has said to him
She was surprised.
that she is surprised that there was virtually no resistance, especially from the intelligentsia.
Absolutely correct.
That was
And
quite a story.
That was quite a thing, yeah. And I believed him. I mean, because he told me this. I mean, a few days after he met her, because he used to walk on and the Ashoka Ghat.
Now, you took a position listening to your conscience during Indira Gandhi's emergency. The one case that you have always been criticized for is Union Carbide,
That's
is
right.
the Bhopal gas
That's
tragedy.
right.
And you say
There's a chapter on that.
there is a chapter on that in your memoirs. Do you regret to date having taken that case?
Yes. In retrospect, yes. Just as one regrets a lot of things in one's life.
Is that your biggest regret?
Beg your pardon? Yes, perhaps it is. Perhaps it is. Because of all the things that took place, which is
So my question is this, and this has always confused me as somebody who's not a lawyer.
Right.
Are there certain cases that a lawyer, an ethical lawyer,
I think so.
should refuse?
Yes, I think so. You see, my example, I'll give you an example. Charkunde, who was a very great lawyer in my opinion.
Yes.
He was a judge in the Bombay High Court. I appeared before him several times on the Bombay High Court. Thereafter, he practiced here in the Supreme Court. And he made it a principle never to appear for a corporation in a corporate chase.
Right.
And I used to wonder why he did it. But now I appreciate why he did it. He's right. You have to have certain norms right at the start, which I regret I did not have. So, and I appreciate that, and I admire him for it. He refused. He refused. Anybody would come with a brief for a big corporation, he'd refuse. Because he was pro-labor. And he was a pro-socialist.
But on the other hand, when Ajmal Kasab, the terrorist who was taken alive in the Mumbai terror attacks, the Supreme Court said this man must have a lawyer. Raju Ramachandran was then, appointed by the court so that due process was served.
That's all right.
Yet you say, personally, you believe Union Carbide did not deserve you and you made a mistake.
Yes, definitely. That I've written.
I think the phrase you used for yourself was you felt you were a fallen angel. That you're not a devil, but you felt you were a fallen angel.
I was so described actually by somebody,
Explain that. Why were you a fallen angel?
Because I was almost angelic in the way I conducted cases and did the things for the government otherwise.
Yes.
But it was much too much emphasis on the government itself, which I should have then realized.
Do you regret the fact of taking the case, or do you regret that the settlement eventually was too small?
No, only the regret is for the taking of the case.
You shouldn't have taken it at all.
Yeah, that's right. The settlement had something to do, because there the blame goes apparently to the then Attorney General, Mr. Parasar, that he agreed to the $420 million.
Yes.
It should have been $800 odd million. I mean, that's a matter of contest, and he would probably say that that was the only way in which he could get some money from the Union government.
What was the stage in your life that you started regretting taking on the case? Was it very much later? Was it during the case itself?
Oh no, but very much later, because I was criticized, and that alerted me to the importance of that criticism. It's not as if you can be criticized. There's no harm in being criticized.
It was a criticism you agreed with.
Beg your pardon? That ultimately agreed with.
Yes, eventually agreed with.
Yes.
Now you...
And one of the major critics was Upendra Bakshi.
Yes.
Yeah, who is a great dear friend of mine, and an outstanding advocate also, outstanding lawyer, outstanding professor, etc. Yeah, great.
Let's talk about your stint in Parliament. There is a chapter on that in your memoir.
That's great fun.
Was it fun?
Great fun.
Was it as you'd imagined it would be?
In the first year, I thought I'd do both things. Go to court and then go to Parliament. But I found that this was not good for me, because I didn't get that same pleasure that I got much later. So after the first year of my nomination in Parliament, then I stuck to Parliament for the entire term and sacrificed my cases in court, etc. Yes. And I found it much more rewarding, much more rewarding.
What did you enjoy the most about it?
Enjoyed most was that the chairman, Mr. Shekhawat, was vice president, was very fond of me for chap. He was always, and in fact, he recommended me for being a pro tem chairman. Yes. And I actually sat on his chair, which I felt very delighted over. And he had all these chaps who were speaking and so on. Now, that you have to do one thing well, otherwise not do it at all. Yes. And therefore, I took this very seriously, and I never regretted it. And I think that was one. I introduced a lot of bills which were not passed, of course, the private members' bills. But that was an exercise with which I was very delighted. And I have mentioned in this chapter that this was one thing which I never felt any regrets for. Never any.
Now, you have said in this conversation and elsewhere that you believe that the collegium sometimes doesn't assert itself enough. Judges need to be, stand up for principles. There was a time, however, when we saw an unprecedented public protest by judges, the famous judges' press conference, when you actually had Justice Gogoi leading those 5 judges. You were very opposed to that. Even though you're a critic of the collegium system, you said that if the Chief Justice of India, you don't agree with his or her rosters, then you have to basically take it or leave it. You cannot go to the public to protest. Why were you opposed to that judges' press conference?
You see, I personally believe that in fact, let me put it this way, that in the very collegium system that we are discussing, why is it that only 5 of the first 5 or the first 3 judges are to be consulted? Why shouldn't? I mean, if the idea is that a person deserves to be brought up from the High Court to the Supreme Court, or deserves to be brought up from the bar to the bench, like Rohinton Nariman was. I mean, and a lot of other judges were also appointed. Yes. Now, there has to be some criteria for that, some extra criteria, some merit in that. Now, why should, if someone is to be transferred from one High Court to another, why shouldn't judge number 5, 6, 7, and 9 also be consulted at least by the Chief Justice? Here
Why
you
does
are
it have to be only those 5?
Why does it have to be? You see, this precludes all this. It becomes a sort of rarefied atmosphere. You are superior to. They are not superior. Everybody is equal. Chief Justice is one amongst equals. There's no doubt about it. In fact, you see, there's a very great example of this, because I've recorded it somewhere in one of my books, and that is when the then Prime Minister Jawaharlal Nehru did not want to appoint the judge of the as Chief Justice, namely the man who was also the advisor to the Maharaja of Kashmir, Mr. Mahajan,
Yes.
Merchant Mahajan, very
Yes.
brilliant judge, as Chief Justice. He asked the one below him that he wanted to, in a way, supersede him and appoint that man. Now, what did this gentleman, Justice Mukherjee from Calcutta, say? He said, Prime Minister, if you choose to appoint me, not only will I resign, because you are not following the convention of the senior most in the court being appointed Chief Justice, but I will ask my other colleagues also whether they wouldn't resign with me. But contrast it with what happened when A.N. Ray was appointed
Yes.
as Chief Justice, was appointed Chief Justice when he was only number 4.
I mean, I just can't imagine.
That there again, he agreed to it, and he didn't even discuss it with his other colleagues.
Yeah. So
Hidayatullah mentions it in his book.
So are you concerned? You mentioned Kashmir, and I have a question about Kashmir. But before that, are you concerned about? There's big debate about how independent the judiciary is or able to be today. Are you concerned? Are there worrying signs?
It's something that affects everybody everywhere.
Yes.
Look at the criticism in America today.
Of course.
It's outstanding between Republican and Democrat.
Yes.
If you are a Republican, when everything is all right, or if you are a Democrat, everything is all right. If you are the other, it's not. I mean, that's a disaster.
That's a polarized kind of
thing, but it has its effect.
But today, when you look at how the courts are functioning, you look at some of the judgments, you look at, especially at the lower court level, what concerns you the most today about the state of the judiciary?
Is the delay. And that's something which is terrible. And I don't think we are able to tackle it for years and years and years. There has to be some, it has to be put on a war footing. The delay in disposals are chronic and catastrophic. And therefore, we should adopt or adapt all sorts of systems from everywhere. Now, take for instance, this happens when if you watch CNN, you'll find that somebody is accused of an offense. How does this offense come in? See, it's not that someone is taken into custody and questioned, and then a charge is filed. No, the FBI or the CBI, etc., makes an investigation, and ultimately makes an indictment. So that the thing the whole criminal process starts with the charge, not the charge sheet. The charge sheet is the FIR, the first in. There's no such thing as first information in America. These are things we should pick up in our criminal law and deal with them, because then you don't get this harassment. You don't get people
where the process becomes the punishment.
Today, the under trials are predominant amongst the people who are jailed.
One of the delayed hearings has been the Article 370 hearing that has finally started 2 years after the abrogation actually.
It should have started much earlier.
They should have started much earlier. As a jurist, what do you think is the central point of law that the Supreme Court has to consider in this case?
You see, there are 2 points. One is that we are a federation, and Jammu and Kashmir, despite the Maharaja saying that he will only surrender 3 subjects to the center and no more.
Yes.
He was part of that federation. And therefore, the question, there had to be an accommodation as to how to decide this. But since raiders from Pakistan had come into Kashmir and there was a tragic situation, you'll find in the debates in the Constituent Assembly, the man who introduced it, Mr. Iyengar, said that until something happens, we had to, at the moment, we have to be content with this Article 306A, which they call. That became 370, and therefore became temporary. And he also mentioned it would be temporary. Now, this happens to be something that the court has to now consider not only the federal structure, it also has to consider why, without the consent of the state legislature,
the assembly,
it has been reduced from a state to
a union
territory.
So
it
you're
is
saying
a sort of a demotion.
The legal question is not so much the abrogation, because the article itself was temporary.
That's it.
It is that the abrogation took place without the consultation of the assembly.
After dissolving the assembly.
After dissolving the assembly.
And therefore there could be no consultation.
And that is
a fait accompli.
And that is the legal point before
that's a legal point, a principal legal point.
There is one other legal question that occurs to me. I could be totally off the mark. That once you end the exceptionalism, let's say for one state, which has happened with Kashmir, there is an Article 371 which allows an exceptionalism for
the whole A, B, C, D, E, F, G. Yeah.
Is there any legality, or is that a political decision that you can have exception?
It's a purely political. I'll tell you what. You see, in one of the states, in fact, that's a reported decision also, there was a divergence of view between a bench of 5 judges, and 2 judges took one view, the other 3 judges took. That could you have a state with a Sangha which only permitted religious heads to be part of the organization to come within our constitution. Now, Chief Justice Venkatachala later became Chief Justice. He said yes, but it was a majority of 3-2. The other judge, who was later Chief Justice also, Justice Sharma, said no, not at all. We can't have religious heads coming into just because that state had that thing before, because ours is a secular state. I mean, that was the whole object. Now, these are very difficult questions. They are not simple. The way I am putting it perhaps sounds very simple, but it's not. It's possible to take one view, it's possible to take another. Therefore, it's possible that the Supreme Court upholds the abrogation, and it's possible that the Supreme Court, but the important is, does it give a reason which convinces the majority of people? That's
interesting. Before I come to the end, which I want to be a little personal about, one other political legal headline is the talk of a uniform civil code.
Yeah.
And again, it is a constitutional suggestion or a constitutional ideal, which has been so politicized, so mired in politics that we can't actually have an honest conversation about it. How do you see the debate around a uniform civil code?
You see, this question arose years ago before 2 very, very distinguished judges of the Bombay High Court, Chief Justice Chagla and Justice Indira Gandhi. Justice Indira Gandhi later became Chief Justice of India. Now, the question was, is there a distinction in the Constitution between custom and personal law? There's a very fine distinction. It's very difficult. It's only a lawyer who can wind his way through it. But they reason that yes, there is. Because in one of the articles in the 7th schedule, which say what is the power of the state legislature to legislate, they have mentioned the word personal law. In Article 13, you will find the word custom mentioned. Now, therefore, there is a slight distinction. How one is to get married, should be the death ceremony, etc., etc. Should there be adoption or should there not? The Mohammedans are dead opposed to it, for instance. because the Prophet was opposed to it, and
Yeah.
so on. Now, these are questions which I think they have to come in time. They have to, as long as people, we must compliment the majority community, the Hindus, for having introduced part of the uniform civil code
by codifying
laws, by codifying laws. As a matter of fact, the person who really codified the Hindu law was a Parsi, Sir Dinsha Mullah, in his book, Hindu law, which was otherwise very confused.
Yes.
And he was able to codify and make a sort of as if he was enacting an act. and it was brilliant, because he was one of the very great jurists of his time. He was a member of the Privy Council and so on. But this is a problem that arises, and I think each community has to adapt itself in our society. And that's why I am. Let me say, are you a proponent or are you opposing? I'm opposed to it.
You are opposed to
a uniform civil code, because there are far too many complications in each little section of the community.
So you'd much rather that the personal laws be codified, each community,
if at all they are to be codified, because I recall that amongst Parsis, for instance, my macroscopic community, under the Indian Succession Act of 1925, and the old days, a daughter or a sister or a mother inherited only half of the property of the person who died intestate, that is without a will.
Yes.
Then a son or a father, etc. Now, that was very unfair. Why should a woman have half the share of a man? And some of us went to at that time I was Additional Solicitor General, we went to Mrs. Gandhi and told her. She said, no, I won't amend it. You come with a cast iron agreement amongst your entire community, because the entire community wouldn't agree that you want this. And it was only 4 or 5 years later, after educating the rest of the community, that now the Succession Act has been amended and a woman inherits on an intestacy as much as the same share as a man.
But what if the community had not agreed?
That would be unfortunate if the community had not.
So you're saying change has to come from within the community?
From within the community. And to say that change within the community, how that is to be organized, this is the personal law. This is
so you're opposed to the uniform civil code?
Yes. I am opposed to a uniform civil code. Although Goa has been very successful.
Yes.
Because the Portuguese had it and they have introduced it, and it's been working extraordinarily well.
Okay, in the last few minutes, let's talk a little bit about Fali Nariman, the person. Now, in your 90s, you're still writing, you're still active. How does Fali Nariman remain young?
Because if I wasn't, I'd drop dead.
No. God forbid. God forbid you have a long life ahead of you.
Enough is enough.
But has it been, the last few years must have been tough. You lost the love of your life, your wife, Babsi. In the book, you talk about her being the mainstay. All jokes aside, really, in a sense, the mainstay who held the center.
Absolutely, she was the pillar of strength.
Yes. Yes. And how do you keep strong, and how do you keep the faith?
Oh, well, I'm very fortunate because my grandchildren come every day.
They do?
Yes.
And they make you smile?
Remarkable, yeah. And their children come.
So talk a little bit about Babsi.
Oh, well, she was a pillar of strength, as I said. Very difficult to live without her, but
such is life.
That's life.
Such is life. Yes. So, well, let's remember her with a smile.
Thank you. Yes, thanks.
I want to read from the last line of your book,
which
basically says that you thrived, you were born in a secular India. You never felt that you were a minority, though you were the microscopic Parsi community. And you
in fact, Sahomi Modi, who was the member of the Constituent Assembly, said in the Constituent Assembly, when the Anglo-Indians were to be given 2 separate seats, that do you Parsis also want? He said, no, we'll fit in to the rest of the community. which is
Yes,
remarkable.
and it's a remarkable community.
Remarkable.
But your last line of this book, of your memoir, say
Right.
you want to die in a secular India. You talk about, this book was written a few years ago, and you were still worrying about whether, that was a deep wish of yours. You were worrying about sort of the rise of religious intolerance. Today, how do you feel about that line you wrote? You said,
I maintain that. I maintain that. I don't take back a word of it. Absolutely correct. Because but for secular India, if we go into a religious India, we are in great trouble, great trouble, great trouble. Despite the fact that the majority community in India is Hindu. But you see, the Hindu religion is such an accommodating religion. It's a remarkable religion. It has accommodated everybody for centuries. And I don't see why it shouldn't do the same.
are you worried today?
I
That-
am. I am. I
What-
am worried.
What,
I'm worried.
what worries you
I'm
the
worried.
most?
I'm worried that everything is. In fact, not only am I worried, at the beginning of the term of the present government, which is right in 2014, I had mentioned this, that we are merging into a Hindu state, not a secular state, but we are now diverting into a Hindu Rashtra, Hindu state, which seems to be something which one section of people like, the other section of people do not. And I don't think that India is cut out that way. This is a very, very difficult
You
trouble.
said this in 2014.
Yes,
We are
and
now in 2023.
Yes, I maintain the same. I maintain the same, but I am afraid we are approaching that state very, very soon.
Why do you think that's happening? There is an argument that
There's
that votaries of this idea say
Yes.
that for too long there's been a hypocrisy around this conversation. There are words like minority appeasement that are often
That's
used
right.
in our
That's right.
politics.
That's right.
So if you were having a debate with somebody, let's say a friend of yours was a votary of the Hindu state, saying,
Yeah.
so what's wrong with the idea?
Yeah,
I'm not saying
yeah,
this is
no,
my
no,
view.
but
What
that-
would you say?
that you see, I would say that that's not the way India is cut out. Because look at the way India is. If you go back into history, we had become a Buddhist state, and perhaps it would have been better if we had remained a Buddhist state. But we haven't. We haven't. I mean,
Yeah.
that was a great achievement of Adi Shankara. I mean, the great Hindu saint who ultimately brought back Hinduism and made the Buddha one of the idols which are worshipped also in the Hindu religion. I mean, that's the great great admiration I have for the Hindu religion. It's a marvelous religion. But then you see, there are different views about the Hindu religion, as everybody has. And ultimately we come to, should you have a Hindu state like Pakistan has a Muslim state, which I think that was the dividing point. That was the dividing point. And that's why Pakistan has not progressed, and this is why India has so far progressed. If we remain a secular state. And that's why secularism is so important.
Pluralism is essentially to India's success.
Absolutely correct. Absolutely correct. I can't imagine any other way in which India progresses.
Well, Fali Nariman, thank you.
No,
I'm
no.
looking forward to the next book. May you keep writing many books.
Thank
We
you.
wish you a long and engaged with ideas life.
Thanks a lot. Thanks
Thank
a lot.
you, sir.
Very sweet
Thank
of
you,
you.
sir.
Thanks.
Thank you.